Welcome to this briefing of the Jerusalem Press Club, JPC, another one in the series Israel Alive and Kicking. We have been running for the international press since the beginning of the coronavirus crisis. Today we host Professor Gila Stopler, who will speak about the emergency corona law that the Israeli government is planning to legislate next week. Gila Stopler is Dean of the Law School and Associate Professor of Law at the College of Law and Business, Ramat Gan, and serves as the Editor-in-Chief of the prestigious journal Law and Ethics of Human Rights. Stopler's area of interest and research include constitutional law, religion and state relations, multiculturalism, women's rights, human rights, and democratic erosion. Stopler served twice between 2010 and 2017 as the chair of the Board of Association for Civil Rights in Israel, ACRI. Welcome. Thank you, Professor Stopler, for being with us. Why don't we start with a short introduction about this law, what is the need for it, and how it evolved, and then we move to Q&A.
Okay, thank you very much, Uri, for inviting me to speak about this topic, and thank you all for joining us to listen. I'll start with some important preliminary facts that would allow us to set the background for the current corona law. Israel has declared a state of emergency upon its establishment in 1948. So it has been under a state of emergency ever since. And this is extended almost automatically by the Knesset every year and was in fact extended in February 2020, right before this crisis. So the state of emergency is allegedly for security reasons, but it was used starting March this year by the government to enact emergency regulations for health reasons due to the corona pandemic. It's important to recall also that in March this year, Israel was ruled by an interim government under Prime Minister Netanyahu, who has failed to gain a parliamentary majority for 3 consecutive elections since March 19. An interim government, constitutionally speaking, is expected to act with restraint and has limited powers relative to a regular government, since it's not a direct representative of the will of the people. And factually, Netanyahu's interim government had at best the support of the minority of the voters. Also at that time, due to the fact that the elections were just held in March 2nd, the Knesset wasn't yet convened, and the government's initial emergency regulations were passed without even any legislative body to supervise them. The power of the government to enact emergency regulations stems from Article 39 of the Basic Law of Government. That article states, and I quote, "During a state of emergency, the government may make emergency regulations for the defense of the state, public security, and the maintenance of supplies and essential services." As you can see, the article says nothing about health crisis. According to the Basic Law, and again I quote, "Emergency regulations may alter any law, temporarily suspend its effect, or introduce conditions." End of quote. So this means that as a result, during emergencies, the government has the authority to enact regulations that supersede Knesset legislation. The political situation at that time was extremely tense for 2 interrelated reasons. First, a power struggle between both sides of the political divide on who will control the Knesset, and therefore who will have the upper hand in the then forthcoming coalition negotiations. And second, Netanyahu's criminal trial on corruption charges, which was due to open March 17. The result was an unprecedented constitutional crisis during which Netanyahu's bloc used the emergency regulations along with their hold over the position of the Speaker of the Knesset, which was also an interim position, in order to do 2 things. First, they used it to suspend the operation of the Knesset against the will of the majority of the Knesset members, until the Supreme Court ruled that this was unconstitutional. And second, it used the interim regulation, the emergency regulations, to restrict the operation of the courts so as to postpone the beginning of Netanyahu's trial. These measures have largely achieved both aims. Netanyahu's trial was suspended for 2 months and was scheduled to begin May 24th. and the center-left bloc opposing Netanyahu essentially disintegrated, and the significant part of it joined the unity government with Netanyahu as him being the current prime minister and allegedly being replaced by Gantz in a year and a half. Now, during this extremely tense political time, the government has passed in the last 2.5 months almost 100 emergency regulations under its emergency powers, which is by far much more than any Israeli government has ever passed during such a short time or even in a year period. These regulations include dozens of severe restrictions on human rights, and they gave the executive sweeping powers, including the power to restrict freedom of movement, to restrict the right to demonstrate, to quarantine areas, and to declare lockdowns. The regulations also gave the General Security Services extensive powers of tracking and surveillance of citizens and allowed them to employ technological measures against civilians, which up to that point have only been used for security reasons against outside threats. Now, this situation, and now we're advancing towards the Corona law, has led human rights organizations to file petitions to the Supreme Court against the prolonged and extensive use of emergency regulations. The argument in the petitions, which was based on prior decisions of the Supreme Court on this subject, was that emergency regulations could only be used when there's no time or no possibility of enacting an equivalent primary legislation. However, once the Knesset is functioning, it should be entrusted with enacting primary legislation, determining the measures to be taken to deal with the pandemic. Furthermore, the petitioners argued that the health crisis wasn't even covered by the permanent state of emergency, and therefore that the government is not authorized to enact emergency regulations to deal with this health crisis. The Attorney General agreed with the petitioners that there is no justification for the continued use of emergency regulations. The court accepted the petition and instructed the government to replace the emergency regulations with primary legislation. And this is what led to the current proposed law. So basically what the current proposed law includes is a framework for declaring a medical state of emergency and for applying restrictions following this declaration. These restrictions are currently within the proposed law, very similar in scope to the restrictions applied on the population in Israel up to this point. The proposed law has some clear advantages vis-a-vis the previous situation, although it is very far from being a best practice in this area or even from being a good law. And now I'll go into some of the advantages and disadvantages. So the most important advantage of the bill relative to the situation described until now is that it clearly states that the emergency regulations passed by the government under the authority of the law will not be applicable to the Knesset or to Knesset members, to the courts or to judges, or to the state controller, to elections committee, to its members, and to the president of the state. Now, this is highly important in view of what happened in March. However, for example, the law doesn't carry any protection for free press. So basically, the restrictions could theoretically be used to restrict the press, although this wasn't really done even in March, but this possibility exists. Another important advantage is that the emergency powers are passed through primary legislation and not just by the government. The fact that the bill creates a special emergency for Corona means that regular emergency regulation can no longer be used to deal with the pandemic. And this is important in the Israeli situation in which the state of emergency is actually perpetual, which means that it can be used at any time by the government. It is also important because it takes some of the initiative from the government and passes it to the legislature where it should belong. Presumably, when the proposed law expires, the government will no longer have the power to use emergency regulation in order to regulate the corona. A last advantage is that the time frames for the use of emergency regulations according to the proposed law are a bit shorter. So the declaration of emergency is only for 45 days, though it can be renewed. The regulations that are enacted will only last for 28 days, though again, they could be renewed. And regulations pertaining to the restrictions of movement, closures, lockdowns are all restricted to 14 days, even though these can also be renewed. And now I'll end with the problems. So there are some major problems with the law. First of all, and in general, the law seems to, by and large, be a duplication into the law of the powers that the government has used during the pandemic, whether they were used justifiably or not. Furthermore, all these powers have been left at almost the complete control of the government. The general idea behind enacting primary legislation is to regulate, in the regulation of emergencies, is to have the legislature closely monitoring the situation and making all the important decisions. But this law doesn't do that. So after the initial stage of the passage of the law, it leaves complete control over the emergency at the hands of the government, including even the declaration of the emergency itself, which is something that should be left at the hands of the legislature under all circumstances. But this bill only gives the legislature a supervisory power, and even that only after the fact. So it can only annul regulations and not legislate them or decide on their content. So the executive remains the central body determining the handling of the crisis, even though there are no compelling reasons to give the executive this authority. Second problem is the severe restrictions on rights whose limits are not clear. So the conditions justifying the restrictions are not clear either. By and large, this leaves much discretion at the hands of the executive. There are specific restrictions that are problematic, such as the unclear in scope restriction on demonstrations, the ability of the government to decide solely by itself, that is, on criminal offenses, the ability of the police to enter private residences without warrants, the extension of policing authority to other state employees that have no training for it. Many of these things that I'm stating are in the current bill. Some of them the government has said, or the current Minister of Justice has said will be changed, but this still remains to be seen. A third problem is that the law authorizes the Prime Minister as the authority responsible for the implementation of the law. This means that as such, it gives him the authority to pass regulations for the implementation of the law single-handedly. Obviously, this is very dangerous, because we would not want to have either the Prime Minister or any other single person having the ability to pass emergency regulations by themselves. And the last problem is that the whole way in which Israel has dealt with the emergency corona crisis is extremely militarized. So there was surveillance by the General Security Service. This surveillance by the General Security Service is still continuing. The military has been involved far more than it should have been. And this militarization of the crisis is dangerous both for human rights and has actually also been opposed to by the Ministry of Health. But it's something in the frame of mind of the Israeli executive that every danger, no matter what its source is, should be dealt with militarily or under security tools. And this is obviously a problem which the new law doesn't seem to be addressing.
Okay. Thank you. Thank you for this introduction. Professor Mordechai Kremnitzer of the Israel Democracy Institute wrote in Haaretz recently that the purpose of such legislation is to allow the legislator to curtail our liberties and oversee the government's actions. But the memorandum of the law fails to do the latter. What is your opinion about this kind of statement?
Yeah, I agree. As I said, there's no the fact that this law has actually taken all the authority that the government had in the emergency regulation. It is simply given the same authority by the law, but the fact that the Knesset members vote for the law doesn't really make them supervisors of the actions of the government. So it's true that after the government regulates the emergency regulation, the Knesset committee can look at this regulation, say, and even annul it if it finds that it's unjustified. But this is a drastic step, so the chances that this will happen are slim. What should have happened was for the Knesset to be given the initial power to legislate all these restrictions. There's no reason. The only reason to give the government the ability to restrict human rights is if there is an emergency which leaves no time for the legislature to contemplate the need for the restrictions. But this is not the case here. So we're now in a case in which the pandemic has slowed down. There's time to sit and seriously think about what regulations are needed, what limitations are needed, and under what circumstances. This hasn't been done. It simply was a cut and paste from the regulations to the law, and the regulations themselves have been very unclear. So they restricted very much, and then it wasn't even clear that these restrictions were necessary. Instead of trying to put positive steps to lessen the need for restrictions, restricting human rights seems to have been, and also seems to be in this current law, the first and almost only step which the regulations and the law allow for.
Can people appeal to the Supreme Court once it's passed, or this is it?
Sorry? It is possible, of course, it's possible to appeal to the Supreme Court against regulations. And the Supreme Court has the power to review the regulations. It has the power to review the proportionality of the regulations. But we have to consider the fact that in the current political situation, the Supreme Court feels that it's in a very precarious situation in which it has to tread carefully and only intervene in issues which it finds essential. So I'm not sure how willing the Supreme Court will be to intervene. Furthermore, the question of, and this is a bit legal, but the question of proportionality in time, proportionality is always the question is how proportional is the measure? The question of proportionality in times of emergency is a tough one because it's an emergency. Everybody is very scared. Everybody thinks we need to, there's no choice but to enact tough solutions. And then the court is even more hesitant to interfere. So the good practice, the best practice is to put these restrictions into law in advance and to give the Knesset the authority to implement them and not give it to the executive.
Let's put it in a bigger context of the division between the three branches of government. It seems that the court is being under attack. Knesset is marginalized. And I think you yourself, when in March they refused to convene the Knesset, you said there's an attempt to undermine or change the mere foundation of the government, of the regime in Israel. And then the government becomes omnipotent. Are we on a slippery slope to some kind of different regime, maybe a dictatorship?
Well, I think you know, we're still not a dictatorship, but we have seen around the world the democratic erosion, which has started prior to the pandemic, and the pandemic is certainly a good opportunity for the executive branch. The dictatorship or the dictatorships always start by the executive branch taking more and more powers and silencing the courts and the legislature. And the pandemic has been a very good opportunity for the executive branch in other countries as well to sort of annex those powers to themselves. We were definitely in a very, very dangerous point in March after the elections and before the Knesset was convened. Now we are allegedly out of that danger zone, but we have been, at least to my opinion, in a continuous process of democratic erosion since at least 2015. It has been accelerated since 2019, the beginning of 2019. So this pandemic now is at a bad time for us in that sense.
How do you explain the relative calm in which all this process is met by the opposition, by the press?
I don't think the press is very calm, but the opposition, this is the problem with is the opposition really an opposition? So for 3 consecutive elections, it seemed that there was an opposition. However, it seems that now this opposition has been at least partly co-opted by Netanyahu's bloc, and it's part of the coalition. And it's been, you know, it's been waiting for the change of, you know, in a year and a half. Even though on the other hand, you could say, you know, if we were in a situation now that we only had a right-wing government with Netanyahu's bloc, I think the situation would have been much more dangerous because you know, there is I'm not a politician, I'm a legal scholar, but there is the question of where could you safeguard democracy more from the outside or from the inside. But it's definitely a problem that the Israeli population is completely fed up with, you know, with all the tension of the last year and a half. And is simply giving, you know, giving all these things minimal attention.
You mentioned the potential threat to the freedom of the press, and indeed invoking emergency regulations, which go back traditionally to the mandatory times. If I remember the language there, which then adopted by the Israeli law, is that the Minister of Interior can close down a paper if it causes panic or unrest or despair in the public. But then, of course, there was the Kol Ha'am case in 1953, in which the Supreme Court said, no, freedom of the press is a privileged right. And only a severe case or extreme case might justify it. Do you see any scenario by which the adopting this law might really threaten again the freedom of the press?
Well, again, I don't think the question is, the problem is a problem of trust. So if you have, and again, I think this is not unique to Israel, it's all over the world. It's perfectly sensible that in times of emergency regulations or emergency powers need to be invoked. The question is whether you trust the government that invokes those powers, whether those powers are transparent, whether the motivations behind those powers are transparent. What happened in March with the imminent closure or even the temporary for 2 days closure of the Knesset and the 2 months suspension of most of the court functions was completely, this was done in very bad faith. There's no question about that, at least in my opinion. So the trust is the major problem here. There's nothing you can do if we've learned something from the last few years around the world, in Europe, Hungary, Poland. If we learned something from the democratic erosion in last year, is that law in itself cannot prevent the deterioration of democracy. You can even see that in the United States, with the American Constitution, which is it's itself. American legal experts say it's full of holes. Our impressive Constitution, which we were so proud of, has, since Trump has gained power, proven to be full of holes. So if you have a leader who is determined enough to find the holes in the legal system, they will find it. Emergency powers, of course, are the biggest hole. And the biggest threat is in times of emergency. We see that all around the world. And it's a very sad coincidence that at the same time that the whole world is experiencing, or that many countries in the world are experiencing democratic erosion, we also have this pandemic that has fallen as a ripe fruit in the hands of would-be dictators. To say that Israel is not under the same danger, I wouldn't say it's not under the same danger. I do hope that this danger will not materialize, though.
One of the concerns is presumably fighting the coronavirus, the government will use those measures or this law to curtail human and civil rights, like allowing police officers to go without a search warrant into houses, or to limit protests in the pretext that it's to fight coronavirus, but actually it's to limit free speech.
Yeah, that's true. This has actually occurred again in March. So this was definitely the case. The case was that emergency regulations have restricted demonstrations. And there were talks in the government, and these talks were even quoted in the newspapers, in which ministers or Knesset members that belong to the coalition or to the interim government said we should ban all demonstrations because these demonstrations are dangerous for health reasons, and obviously not for the reason that they're against the government. So we were definitely there, but this has not happened. And again, I say, relatively now we are in, so I think there was an attempt. That attempt would probably have gone further if there wasn't the resistance. So the Supreme Court has resisted partially, and that resistance was extremely important. For example, it resisted to the Speaker of the Knesset's attempt to close the Knesset. It did so under the risk of losing its reputation and confronting head-on both the executive and the legislature. So one of the problems in Israel is that the executive and the legislature, and this is an endemic problem of the Israeli system, which is that the executive and the legislature are almost the same thing, because the executive has full control through the coalition over the legislature. This has actually been even admitted or even stated by the court several times in decisions in which the court annulled legislation, saying that this legislation was actually the attempt of the executive to use the legislature without giving the legislature time to consider or the ability to consider its actions. So if we have a court stating that the legislature is so enmeshed with the executive that it doesn't even have its own free opinion anymore, then this obviously shows that we have a big problem here. So the problem here is that the courts are, let's say, the only barrier between full control of the executive of both the legislature and the Israeli system on the whole.
You talked about the erosion of democracy, and this is the last question. And the fact that with a weak Knesset, a strong government, and a Supreme Court under attack, it seems that the last hope is with the organization or civil rights organization or the civic society organization to stand up. What can we learn from the history of erosion of democracies that applies to the case of Israel?
What we can learn is that there are, various points of attack that the executive directs their arrows at. So the courts are one, the press is the second, and organizations are the third. So we see, for example, in Hungary, the anti-Soros campaign, which is also an anti-Semite campaign, and which in a completely twisted way is also supported by the Netanyahu, let's just say at least by his son in Israel. So the idea of human rights organizations being a barrier or an essential part of the struggle against democratic erosion is clearly true. However, in Israel, there have been attempts to limit human rights organizations, starting in the government of 2015. Again, these attempts started out very strong, ended up being weaker than the government may have wished, but they're certainly there. And the discreditation continues, the vilification continues, and this is extremely hurtful for the ability of those organizations to struggle against the government.
Thank you so much, Professor Stopler. Stay tuned to our next webinar on Sunday at 11 a.m. with Ronnie Baron, former finance minister, who was in charge when Israel went through the economic crisis of 2008, and who will speak about the right way to come out of the current one.